Hello everyone, this is Crypto BitLaw, here with another blockchain legal brief, and today we're going to discuss Binance and their role in a Tinder crypto scam related lawsuit. But before we dive in, please, if you enjoy this content, hit that like button and subscribe to our channel. And with that said, let's jump right on in and see what this is all about. Alright, so as we can see here, Coindesk reports that Binance asks to be removed from crypto romance scam lawsuit. The Cayman Islands company argued it's not subject to the, quote, personal jurisdiction of U.S. federal courts. They say Binance, on Thursday, asked a federal judge in Texas to be removed from an $8 million lawsuit claiming the crypto exchange, quote, aided and abetted a romance scam. Plaintiff Divya Gadasalli is suing the Cayman Islands company in federal civil court over Binance's alleged role in the scheme, which she said involved cashing out crypto she had bought on Coinbase. Gadasalli is also suing TD Bank, Abacus Federal Savings Bank, and the Poloniex crypto exchange, among others. Law 360 first reported the news. In its motion to dismiss, Binance told the court that Gadasalli, or whatever, based her allegations on paper-thin assertions and failed to establish a claim. In addition, the exchange said it does not do business in the United States, and, as a foreign entity, it is not subject to the personal jurisdiction of U.S. federal court systems. Binance cited a number of recent dismissals of other cases in federal court, including in New York, Florida, and California. Lawyers for Binance did not immediately comment when called Thursday. Lawyers for the plaintiff did not pick up the phone. Alright, so as we can see here, part of the reasoning behind Binance's motion to dismiss is they're arguing that they're not subject to the personal jurisdiction of this federal court. And if you can recall from some of our previous videos, in order to have a properly filed lawsuit, you need jurisdiction, both personal jurisdiction and subject matter jurisdiction. The court needs to have jurisdiction over the person and over the subject matter that gives rise to the case. And in order to have personal jurisdiction, you need to have such minimum context with the jurisdiction of the particular area where the court is situated in order to not offend the traditional notions of fair play and substantial justice, right? Now, the issue is here, if we take a deeper look into this suit, we could see, here's a caption from a pleading in this case. We could see that the plaintiff name here was Binance Holdings Limited, doing business as Binance, right here. And if you can recall from our analysis of the Hex class action lawsuits, that was one of the main issues in that case, whether or not the court could actually establish jurisdiction over Binance, because the way that Binance is structured, there's Binance, right? Binance Holdings Limited, and then in order to operate in the United States, Binance set up this subsidiary company, BAM Trading Services, which operates as Binance US. And Binance US is the actual company that does its operations on behalf of Binance, the larger holding company that operates in the United States. So they could have misnamed they probably named the wrong person in this particular lawsuit. If that's the case, if Binance is saying, hey, Binance Holdings Limited is saying, hey, we don't operate in the US, you probably should have gotten BAM Trading Services doing business as Binance US, then that would have been the proper party to name. So based on that argument, I think Binance is likely to succeed in this motion to dismiss. And so the court may allow the plaintiff to go back and amend the suit to properly name Binance US or BAM Trading Services, but that remains to be seen. But continuing on, we'll do a little more analysis here and kind of hash out more of what's going on in this case. Here's a copy of the parties and attorneys listed on court listener docket. We could see that the name of the case is Gadasalli, I think I butchered that name earlier, versus Bulasa, and it's out of the Eastern District of Texas, and it's based on diversity jurisdiction, so we have plaintiffs and defendants, parties from different jurisdictions, right, and the amount of controversy, I think it's over 75,000, I can't remember what the exact threshold was. Maybe it's 60, I can't remember off the top of my head. But we could see you have defendants here, Abacus Federal Savings Bank, Binance Holding Limited, who we talked about earlier, Danyon Lin, Dong Lon, Jerry Bulasa, Poloniex LLC, TD Bank, and the plaintiff is Divya Gadasalli, right? And so let's take a look at the docket. Okay, here's a copy of the docket. It looks like this case was filed March 28th of 2022, so that was about a month or so ago. And they wanted an emergency temporary restraining order without notice to defendant Bulasa and Gadasalli. And the case was assigned. There was a summons. Let's keep going. They denied without prejudice the motion for the temporary restraining order. Then they filed an emergency motion for a TRO renewed. And let's keep going. Counsel are advised that the court has not opted out of this court's local rules concerning courtesy copies. Okay. And a memorandum in opinion denying without prejudice the emergency temporary restraining order renewed. And then here, fast forward to today, or April 20th, there was the motion to dismiss for lack of jurisdiction from Binance Holdings. Okay, so here's a copy of the court's memorandum opinion and order, right? And I think if we go through this background section, this could give us a nice overview as to what's going on in this case. But ultimately, we see that the motion for temporary restraining order was denied. But let's dive into the background. It says, on March 28, 2022, Plaintiff Gadasalli filed her complaint, in this case against defendants Bulasa, Lin, TD Bank North America, Abacus Federal Savings Bank, Binance Holdings Limited, doing business as Binance, and Poloniex LLC. According to the complaint, Bulasa assisted by Leon and Lin, conned Gadasalli out of $8 million worth of cryptocurrency. In May 2021, Bulasa and Gadasalli met through the online dating service Tinder, and formed what Gadasalli believed to be a genuine romantic connection. Bulasa appeared as a diamond in the rough, a young, hardworking New Yorker who had honorably taken over the family business when his father fell ill. To Gadasalli, Bulasa offered the promise of romance and true love that Gadasalli, I don't know why that's so hard to pronounce, had long searched for. As their relationship progressed, however, Bulasa's love turned into financial demand. Bulasa portrayed himself to be a, quote, very successful and savvy cryptocurrency investor, and in a short time had convinced Gadasalli to, quote, use some family funds to invest in cryptocurrency. On May 13, 2021, at Bulasa's instruction, Gadasalli made her first wire transfer in the amount of $10,000 to a bank account held under Leon's name. In return for the funds, Leon then transferred cryptocurrency to Bulasa, purportedly for Bulasa to invest on Gadasalli's behalf. Over the next few weeks, Gadasalli made 3 more transfers totaling $350,000 each time to an account held by either Leon or Lin. Okay, before I go on, I mean, how are the red flags just not going off? You're going to transfer $350,000 to some stranger on the internet? I mean, come on. Really? Wow. Let's keep going. I don't know why this always touches on crypto, though. Let's keep going. Bulasa then convinced Gadasalli to open an account with U.S.-based cryptocurrency exchange platform Coinbase. Gadasalli funded this account, quote, with additional family monies that were used to purchase cryptocurrency that was subsequently transferred to cryptocurrency investment firm accounts operated by Bulasa. The nearly $6 million Gadasalli funded into her Coinbase account was then used to purchase Tether, a type of stablecoin cryptocurrency hosted on the Ethereum and Bitcoin blockchains. I don't know if I've ever heard of Bitcoin-based Tether, but okay. The Tether was then sent to an investment account Bulasa allegedly opened for Gadasalli that was maintained at cryptocurrency investment firms Coin Fund and Digital Fund. In total, after many subsequent transactions occurring through 2021, Gadasalli wired over $8 million to Bulasa, Lin, and Leon. Though Bulasa told Gadasalli that the investment accounts had grown to a value of approximately $10 million, Gadasalli was, quote, unable to withdraw any of those funds from her account. In fact, Bulasa, quote, provided multiple implausible excuses as to why Gadasalli could not retain control over her own assets. Yet, blockchain analytics successfully traced Gadasalli's funds to cryptocurrency wallet addresses under Bulasa's control. Frustrated and unable to see any viable way out of the financial hole in which Bulasa had placed her, Gadasalli filed suit. Again, Gadasalli brought claims of fraudulent inducement, negligent misrepresentation, conversion, which is civil law theft, and civil conspiracy. Again, Leon and Lynn for against Leon and Lynn for civil conspiracy, against Binance and Poloniex for aiding and abetting conversion, and against TD Bank and Abacus Bank for the imposition of constructive trust and disgorgement of funds. Gadasalli subsequently filed an emergency ex parte motion for temporary restraining order, or TRO, against Bulasa. The court denied the motion without prejudice for counsel's failure to certify its efforts to give notice of the motion to Bulasa in accordance with Federal Rules of Civil Procedure 65. Okay, so that's why the first one got denied. And one can only speculate, but it's more likely than not that the plaintiff here, Gadasalli, tried to get the TRO against Bulasa in order to prevent Bulasa from disposing of those funds and to refrain from, doing anything that might put those funds at risk. That's why you would get a TRO. It's to get a court to order someone to either do something or not do something, right? To restrain yourself from doing something. On March 30th, 2022, Gadasalli filed the current motion, a renewed request that the court issue an ex parte TRO against Bulasa. Specifically, Gadasalli requests the court freeze Bulasa's assets, including certain cryptocurrency accounts and cryptocurrency wallet addresses. Okay. Well, I called that one. Well, I guess touching on this, if you get a court order and it's in a centralized stablecoin like Tether or USDC, a court could send Circle, which is they maintain the USDC stablecoin, could send Circle in order to freeze those accounts, right? To freeze the funds that are linked to a specific wallet. And Circle would do that. I'm pretty sure it's the same thing with Tether. If, what is it? I think BitMEX, or I forgot which exchange is the actual subsidiary holder of Tether. If they have significant contacts in the United States, and they would actually abide by this court order, it'd be the same thing. They would freeze those accounts. Bitcoin, you can't do that, right? But if the funds are on an exchange that operates in the United States, it's the same thing. You can get the exchange, you go to them with a court order, and they would freeze the accounts in the exchange linked to a certain account, right? And so then the court goes through the legal standard, and apparently, I guess, the court denied the initial request because she failed to certify in writing any efforts made to give notice to Bulasa of the motion. And injunctive relief, let's see, purely legal, the complainant fraudulent inducement, the remedies, money damages are not typical available in equity. Because Gadasalli seeks purely legal relief and money damages against Bulasa, the court does not have power to issue an injunction freezing Bulasa's assets. Therefore, Gadasalli's request for a TRO must be denied. Okay, interesting. Money damages are not equitable, so you would need equitable relief, and you're not going to get that. So yeah, to sum it up, I think Binance is ultimately, they're going to get dismissed from this suit because Binance, as we have learned before through the Hex-based lawsuits where Hexagon was suing CoinMarketCap, which is owned by Binance, and all of the legal issues surrounding jurisdiction in that case, Binance does not operate in the United States. It's actually BAM Trading Services, which does business under the name of Binance US. So they should have named Binance US. The plaintiff in this case did not get their TRO to freeze these funds, and I just can't believe if you're gonna, I don't know. I mean, if you have access to $10 million, wow, to lose it like this. I mean, I wouldn't say you're asking for it, but I mean, come on, man. You're going to really transfer tens of millions of dollars to someone you don't know over the internet based on a hope and a prayer that you found some sort of long-lost romance that you desire, and then go along with their scheme to convert it into crypto and keep giving them more. If that's not raising red flags, I don't know what is. But I thought that this case was interesting. I guess we'll keep an eye on this case as it develops. I doubt that this plaintiff's going to get any sort of relief. I mean, if these defendants, the individuals, Bulasa and Lynn and Leon, actually in the United States, maybe you could rope them up and get some sort of relief from them. I doubt Binance is going to have any liability. Poloniex, I don't think that they aided and abetted. I think that requires a heightened level of malfeasance or involvement that these companies just weren't involved in. They weren't participating in. I think a lot of the onus falls on these individuals that were the scammers. But since the funds were already converted to crypto, I mean, if it's converted to crypto, good luck getting it at this point. But interesting nonetheless. Hope you guys enjoyed this content. If you did, please hit that like and subscribe button. We'd appreciate that. And with that said, we'll see you all in the next video.